And welcome to the January 6, 2015 Town Work Session for the Town of Ossining. Please stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. So we're going to wait a couple of minutes to finalize our number one, which is finalize the changes to the town ethics law. We're going to wait till everyone gets here, which being very slippery outside, we want everyone to be careful when they're driving. So we'll go into number two, which is fee schedule review and Dale Cemetery fees. There was two questions that came up. Maddie, do you want to?
Yeah, sure. So when the board had discussed this, I don't know how many weeks ago now that we last had a work session. It was like a month. There were a couple questions that came out of it, one of which had to do with providing a PDF copy on CD-ROM of the tax map. So that came from the assessor's office. And the charge is $150, I think is what it says in the fee schedule. And so Fernando, who's our assessor, his explanation was that it's available free of charge on the town website for anyone who wants to use it. But it's banks specifically like to keep them for their files. So they like to have a hard disk that they can pay for, and $150 is about what he thinks is in line with what other municipalities are charging.
And what it costs in somebody sitting there and producing it.
Right.
So, yeah.
And, it's something that we pay nearly $10,000 a year to have our tax maps maintained. So it's, it's a good chunk of that, even if, only two are sold. It's a way to recoup some of that money. And then the other questions had to do with, one of them was a blasting fee that the board was wondering why it was not in the fee schedule. So John has an explanation of that. And then about the copies of certificates of occupancy. So I printed out the email. I gave it to you.
Oh, here, I'm sorry.
Yeah.
I'm sorry. So the Town Blasting Law, Chapter 89, was amended in 1999. It indicates that our department shall collect all fees, but no fee is stated. You may want to explore this with Wayne and the town board. I would recommend $500 for this application. So again, a fee schedule is a living document. We're not going to start that whole discussion tonight, but we can always change that at a later time. But there definitely should be some fee for a blasting permit.
And I would agree with it being pretty high.
Yeah.
If you're going to start blasting.
Right. Regarding CO copies, we have two fees. Under FOIL request, we are limited to 25 cents a copy per page. These copies are not stamped or certified copies, but contain a raised seal from our office. These copies have the ability to be altered, and we won't accept them if anyone comes back years later with one. Second fee is $25 per copy, which is charged when doing title searches. So you can just go in and get a copy for 25 cents a page. Okay? So the second fee is $25 per copy, which is charged when doing title searches. So a title company is doing it. Yeah. These copies are marked as certified and also carry our raised seal. While they can be copied the raised seal would not be present to show it was issued by us. Okay? So that's the difference between the two. So in both cases, on the fee schedule, you can get it either free or at a very minimal price, or you can get it when title companies come in as part of their regular service. They get all C of Os, and that's what the banks, Wayne, correct me if I'm wrong, the banks are really looking for all C of Os to close on mortgages right now, right?
Yes, part of the searches.
Right, much more than before.
Yeah. Well, not just the banks, but any.
Get closer to your mic and turn it on.
Any person buying a property through their attorney is looking to make sure that the COs are all in place for all improvements.
Right.
So it's the banks as well as part of the process.
Wayne, are there raised signatures that are required in that process?
No, just photocopies, that come from
Either the web page or...
Well, they
from
go
the building department.
Yeah.
Directly from the building department.
Okay.
And the title companies charge the applicants or the home buyers for the service, irrespective of whether they have to pay the municipality for it or not.
Okay.
So if you don't charge, then the buyers are getting charged anyway, and the profits all going to the title company under those circumstances.
So anyway, was the two. So we do have it quite inexpensively for somebody that just wants to get their copies of their CVOs and stuff like that. Does that answer your questions? Does that answer your questions, sir? You know, but yours, we carry on, and we'll talk about the blasting thing, you know, again. The other part of that item, we just went to number 2, sir, Mark, instead of 1 first. Okay, so we're fine. Was Dale Cemetery fees in 2013. We changed the fee schedule for Dale Cemetery for interments and for grave sites and everything. And what we've come to realize is that in some sections of the cemetery, so we already did these big increases. Well, not big, but increases. In some sections of the cemetery, deeds are changed quite regularly. Okay, especially in the Asian section of the cemetery. I mean, it is an ongoing, not challenge, but it's an ongoing. You're constantly working on this.
What does that mean? That means they buy a plot and then they sell it to somebody else?
Yeah, they usually buy like 20 plots, and then they'll sell 3 to this person, and so now you have to void the original deed. You have to issue them a new deed with the 17 plots and somebody else with the 3 plots. Then the guy with the 17 plots might come back to you later and say, well, I've got these 17 plots, but I want to come back and I want to now sell these 5 plots. So there has been, now when you buy a plot, you get a deed, period. It's part of the price of the plot. We would like to suggest that we charge $50 for change every time a deed is changed. It's time consuming for us. We have to mail them out again. It's a lot of it's quite a bit of work. It's quite a bit of work to maintain them. There's books that have to be kept with all the deeds in it. We're constantly working with those books, and I think it was number 1. It will make people more conscious when they're voiding, because they void deeds and then they'll void the deed again the next week, you know, because they'll say, well, I want to go to this guy and I want to go, and there's, and to put it mildly, it's a process. So I would like to suggest that we, as part of our fee schedule, change our Dale Cemetery fees to include when you want to revise, void, or amend a deed, there's a $50 charge.
Administrative fee.
Administrative fee. Put your mic up, please.
Is there also a filing requirement, of the public record, or is that only,
No, it
are the
goes
deeds only maintained internally by the
I think
Dale
that they're not
Cemetery?
recorded with Westchester County, to my
No.
knowledge.
No, they're maintained at the cemetery, which is something that we're doing as a project too, because we're going to go after a Sarah grant to back them up, because right now they sit in that house
Do we have backups of these?
in fireproof
Deeds?
boxes. But it's file cabinets after file cabinet, because you have a deed, you have a card, and all of these are maintained through the whole thing. So, and they're being maintained now. In fact, we've done a lot of catching up, and so it was a tremendous amount of work, and we've now given it over to the confidential secretary, but we did a ton of work catching up, so we're with stacks, you know, so it's done now, but moving forward, we'd like to do that in our fee schedule so that we can alert people, especially chronic deed changers, that we will be having a $50 fee to be paid in advance to changing the deed.
There's also probably, I mean, the reality is there could be some profiteering going on anyway when these things are being flipped, because that's really what it is. It's buying these deeds and then flipping them and then flipping them again.
Right.
So,
I didn't even know you could do that. I mean, this is kind of news to me.
well, it's a commodity. It's an asset. You could sell. There's no prohibition against selling it, and that's what people do.
I thought, so you
This is
didn't
considered real property, right?
It's a form of real property. It's an interest in real property.
So it's not something that you have to buy for yourself and your family?
No.
No. Oh, no,
Well,
no,
you
we
can, but you certainly.
No. I'm saying I did.
I
it
mean,
never,
the whole
No,
bulk
well,
sale
it-
was
that-
was to a middleman to begin with. I
Right.
mean, or a group that was basically brokering out these cemetery plots.
Right.
So
But
that
the-
only pertains to an in-ground plot, right? Because if you're cremated, there's no plot,
Well,
Well,
there,
Airspace.
or is there?
Well, what do they have those called? What are they called again? The
Crematoriums?
Columbarium?
No, the
Columbariums.
columbariums.
we do have a
I think it's
columbarium.
what they do to get the ashes.
No, a columbarium is where you put you go into a sleeve and you have a plaque. It's like that monument, and we do have one at Dale Cemetery, and we actually have two funerals using that columbarium this week. So, but I just wanted to put that out. We believe that our pricing is in line with other cemeteries as far as grave sites and internments, and then the foundations for the stones and everything. Learned an awful lot in the last 4 months about cemeteries. So,
Another skill set you have.
oh gee, what I always wanted to do. Anyway, so does anyone have any objection to that?
No.
You heard about the line outside the cemetery
They're dying to
school,
get in.
right? And everybody's trying to get in.
Oh my God,
Trying to get
terrible joke. Anyway, thank you very much. So we'll put that on the fee schedule and we'll make it whatever the resolution is.
Extremely fair and reasonable, by the way.
Yeah. Yes, it was asked to be higher, and I thought that was appropriate to at least start with, and we'll see what it does. At least pays for the time it takes to do this work. Yeah, the station. we have to buy the spatial stationery, so it's like guarded with. I accidentally printed a fax on it and was not well received.
You don't understand because
I was told by someone in the office, just rip it up and nobody will know. Anyway, I know. No, it was not you, because you're the one that would. Anyway, so that takes care of our fee schedule changes, and next week is our reorg meeting, so that takes care of our fee schedule changes and our Dale Cemetery fees. So we're going to go back to number 1, and we're going to finalize, hopefully, the changes for the town ethics law. Mark, you want to come up? Stuart, do you want to come up and join us? Okay. You're more than welcome. I just want you to know that. Good evening.
Happy New Year.
Happy New Year.
New Year.
So, I assume that everybody followed the flurry of activity of the last couple of days. I brought I don't know what iteration we're on now.
But it's as far as you're concerned, it's the latest and the greatest, right?
Yes.
Okay.
If anybody needs copies, I
Yes,
have.
we all, yeah. Because
Okay.
we didn't make them, because you said you were bringing them this
Okay.
time. So we figured we'd save a tree,
So, here they are.
except,
And I was
Oh.
combing through for 9:45 p.m. Couldn't find it.
it
Okay.
was there. Yeah.
Does that's the,
Without
Well,
the
wait,
red
what's the-
line?
It's without the red line.
Yeah,
it's without, this is, okay.
you have one.
Yeah.
if that's the-
Okay. So, here.
Thank you, sir.
I think I have enough. That's from last night. That was the last one from last night.
And decent sized font and everything, so it's very good.
Oh, that doesn't,
I
don't know what that-
yeah, the clean copy. I just mean.
if you look on 4, there's one line that's struck through. Okay. I started to lose track myself.
Okay,
Okay, so I'm certainly willing, do you want me to go through an explanation
Yeah.
of what's been done?
yes.
Okay. Since we were here in October, we obviously this version now has no red lines, no indicated changes. The changes have simply been made. So again, 20-7 in summary talks about the terms of the members being 5 years, of there being 5 members of the Board of Ethics as opposed to the present 3, I believe, and with at least one not being an attorney. And it also talks about the way in which, once this is reorganized, the way in which people will come in and serve staggered terms, and then eventually everybody serves a 5-year term with with no two people's terms running out in the same year. 20-8.
Mark, may I?
Yes, sure.
Just in-
Go ahead.
For that particular issue, does it take into consideration a resignation?
Yes. Basically, what would happen is that if somebody resigns before their 5-year term expires, they would be replaced and serve out the remainder
Serve out the remaining term.
of the term. Yes.
Thank you.
We've learned that.
Yes.
And I also saw that, so I realized I didn't read this correctly. So the town attorney or deputy attorney will just be an advisor and not vote,
Yes.
right?
Right.
I
That's what we decided,
misunderstood
yeah.
that before, because I remember,
At the very, very beginning of the process, we did that, yeah.
yes, but I misread
No.
what
Oh.
it said,
Right.
and now I'm clarifying it.
Yes.
Okay, good. Move
Okay.
on.
Okay. So 20
We got through one whole paragraph.
tw-
I'm going to hold my breath through each one of them.
No, we're gonna get to a few of them.
20-8 expands the duties of the Board of Ethics to include not just advisory opinions, but also the obligation to conduct investigations. It also describes the way in which an individual would file a complaint against an employee, how and when that complaint would be served on the person who's the subject of the complaint, the investigation process, and ultimately resulting in the town board either accepting, rejecting, or modifying the findings of fact that the Board of Ethics made after it conducted an investigation, or if sooner it decided that there was just no basis to move forward before doing an investigation.
I have a
But
question.
it's very important, excuse me, it's very important that we understand that there's ethics opinions, and then there's ethics when you're actually making a complaint about someone. It's two
Yes.
different things. Yeah.
That's right.
Yeah.
So to clarify, let me ask about that. So, because I know I brought it up and then later, but,
Yes.
so the opinions would be only in response to, board, employee, or someone doing business. And the reason is because how is an opinion, just if you could quickly clarify why that would be expressly in only those three groups that would get an opinion?
Well, it's actually two categories. First would be town employee, and a town employee by definition is anybody who's employed by the town in any capacity, whether that's an elected official, an employee who's either union or non-union, and any volunteer who's appointed to serve on any board. So that by definition, under the statute as it presently exists, employee covers those categories of people.
Okay.
And then, yes, somebody who has a contract with the town that exceeds $25,000 in value.
So my question is, why is it relegated to just those particular categories?
Because those are the only people who, by definition, under the general municipal law and under the Code of Ethics as it presently exists, would be the subject of an ethics opinion. Because there's no action to be taken against anybody except an employee who violates the Code of Ethics, or in this situation, a contractor who has a contract of more than, or a vendor who has a contract exceeding $25,000.
But it would be more, it's more of, if you want to ask an opinion is more of a question. So it's like, I have a question.
Right.
Someone used government information to write a book, or, is that legal? So you're asking them to research that. And it's-
But I guess my question
No,
is
it just, yeah, is
why-
that something?
For
that-
instance, if it comes up in
If
I.
I can just jump in for 1 second, an advisory opinion is usually sought before a person, in this case, an employee
Oh, okay.
or a contractor who's
proposes to do something and wants to
it's
know.
a contemplated action. They're
Right.
saying, in essence, is it okay for me to do that?
Right.
Okay, so,
Because-
but
Right.
but
It's-
it could
it's a-
also be, could it not also be that someone just says, is this the right way to use something? Is this the right way to use?
Any action.
Yeah.
anything.
Sure. Yes.
And all you're asking is it right or wrong to do it? Right?
That's right,
And it
yes.
might be a learning experience for the rest of us, and it might be, you're right.
Right, which is why our statute also says that that if the board is asked to give an advisory opinion, and if it renders one, that the advisory opinion should be made public, redacting the identity of the person who asked the question. Because it is supposed to be a learning experience. That's exactly what it's supposed to be.
It's also supposed to give a person a degree of certainty as to what they're doing.
Right.
If they're contemplating.
Oh, I
an
like
act-
that beginning one. If I did this, would that be within the
Right.
ethics? It would be ethical
And
if you
then
had that.
potentially not subject them to criticism because they checked in advance and they were told.
Right.
they
Well,
were
you're always
qualified.
subject to criticism.
Well,
Right, yes.
different type of criticism.
No, and to Wayne's point, the New York State Bar Association and even the local bar associations will issue advisory opinions if lawyers want to know if something that they're proposing to do would potentially violate the code of ethics. And judges have the same resources.
Oh,
There's
okay.
So this is very similar to
I
that.
think that that's the key about this is in terms of understanding is that these are, it's if somebody is an employee and has a part-time job somewhere else or has it's one of those things. It's where you're trying to figure out whether or not you can have this and that or whether you are violating some kind of code or if a contractor does business in one way and wants to. So that I think clarifies for me why it would be within those
Yeah.
groups.
And if you look at general municipal law, I think it's Article 18, generally, that statute is, our statute is actually more ethical, if you want to call it that, than the New York State statute, because the New York State statute contemplates generally financial conflicts of interest. This goes farther than that, so.
And that's what you can really do at home rule is really taking
Yeah.
the state, whatever the state rule or law is, and making it even more stringent. Okay.
Exactly.
Okay.
Okay.
Okay, great.
All right,
Moving on.
so,
Are we still on page 2?
We are.
no, I was actually,
Oh,
I'm
not.
sort of summarizing
Oh,
the-
yes.
the
Yes.
subsections, not
Okay.
necessarily going page
Okay.
by page.
Oh, okay.
I'm assuming that people have had a chance to read this because
Yep.
we circulated it around a lot.
Mark,
Yes,
if I may at this point,
yes.
in the body of these sections,
Two- on
several
page 2?
sections. Yeah, page 2 and on into the rest of the verbiage. There's reference to the process by which we communicate. The board, the town board communicates with the complainant,
Yes,
communicates with the clerk, and for the time being, my interest is the communication between the clerk and the requirements of that. Has the clerk reviewed your changes, or any changes having to do with communication
I
like
have
that?
not, it's a good point, and I have not consulted with the clerk about this.
Can I recommend that would be a good idea?
Sure.
Well, maybe at the point where we actually make
This
the
is-
decision and
Yeah.
then.
This is
I
like
mean,
the beginning of a quite a lengthy, this is only getting this part done is, there's another whole process. We have public hearings, and we will definitely bring the clerk in and the deputy clerk.
How were they conducted, et
Yeah,
cetera, et cetera.
right, and to make sure that everybody's on the same page, yeah. But
Yeah.
it's getting this to where a point where we can call for a public hearing and let the public read it and let them come back with any information that they want to with us and stuff like that. That's where we're trying to get to tonight, to get to that point that we can move it to the next step.
The reason I say that is because I personally, I don't know how my other board members feel, but I personally was a little bit confused with regard to the process when there is communication back and forth, and who's responsible for it, and the timeframes involved, 5 days, 30 days,
Very
that
similar
sort
to
of
a
thing.
FOIL.
Yeah.
Yeah, it's very similar to a FOIL.
Yeah, well, as far as the communication is concerned, a person who wants to file a complaint against an employee, alleging that they've somehow violated the Austin Code of Ethics, is required to file that complaint with the town clerk. The town clerk is required to transmit it to the Board of Ethics. And that's one of the things, one of the questions I think that Kim raised yesterday in her communication, because when our committee drafted it, we had first suggested that the complaint be transmitted in the first instance to both the clerk and the town board. And Kim, I think correctly, indicated that before there's any real finding made, maybe the town board shouldn't see it. It's probably better if they didn't let the Board of Ethics do its work, then transmit.
Takes all of that question about out of influence or anything like that out of it.
Right. And also just the possibility that by human nature, something might slip out before it should. Which is not to say that these findings should never be made public, but the question is, when should they be made public? So we did last night modify it to the extent that, at least in the first instance, the clerk gets the complaint and then transmits the complaint to the Board of Ethics.
In a confidential fashion.
Yes.
This is
Right.
the same process for a town employee or a non-town employee?
Yes.
Same
Yes.
Can I ask about that on the 3? So we're on page 3 at number I.
Yes.
When we say town, do we mean the entirety of the town, or do we mean the unincorporated town?
What are you talking about 1A?
The the
An
a
employee
town
employed
employee and
by the,
It would be any town
it's
employee.
B1, yes.
It would be any town employee, whether they work for the town general or the unincorporated.
yeah, because, well,
Yeah.
they're just employed by the town
Yeah.
anyway, right? There's
Yeah.
no,
But it doesn't,
right.
I think I'm trying to see, you're right, what I'm trying to say is when it says, the owner of a residential or commercial real property located within the town or
Right.
business, I'm trying to figure out, are we talking about the town of Austining within, that includes, as Sue loves to say, 100% of the village of Austining, 90 whatever percent of Briarcliff, and the unincorporated town, or are we talking about just the unincorporated town?
No, the answer to your question is the entire town.
Okay.
Because.
It's almost like
I
a
have no more
court.
question now.
If a village has a court, they can always go to the town court too,
but it
you
doesn't
know,
apply to, we don't have jurisdiction
over the
village
employees.
No, I understand. I
Well,
think,
there are town-wide functions, which
Right.
the
Right.
assessor and tax receiver. So to the extent that if somebody.
And the town board.
And the town board.
Town board is
If
townwide.
somebody in the village of Briarcliff, the 85% of it, or the.
91.
90%, I'm sorry,
91.
has, raises
I
an
guess I
issue or
don't say it
whatever it is, or.
You do.
or-
You do. You do. I think the reason why I was asking was because I was trying to clarify a situation where somebody who lives in the village of Austining sees, hears, or thinks that somebody who works for the town did something and they can't come and make a complaint. That's
No,
what
they
I was-
can.
Right, I was
Oh.
trying to clarify
Okay.
whether, so I understand that now when we say town, we mean
Right.
Yes.
town.
Town means
Excellent.
town,
Thank you.
Town equals town,
yes.
Right, okay.
okay?
And then 3.2, you said, B2, you said you changed it so that now it doesn't. The complaint shall be filed with the town clerk. This is what you were asking. Within 10 days after receiving the complaint, the town clerk will transmit 5 copies
Oh,
to
this,
the members of the Board of
Right.
Ethics and to the town board.
right,
That's right.
this, apparently this deletion did not happen, even though I
Okay.
thought it did. And that's absolutely correct.
Okay.
That should be out.
So it's, period is
So-
after ethics, right?
Ethics.
Exactly, yes. Okay. And then, the rest of it, I think, can remain as it is. It said, after that, it says, subject to any contrary provisions of this article or as otherwise authorized or provided by law, the town clerk, the town board, and the Board of Ethics shall keep confidential the complaint and its contents. Well.
So
that's-
no matter where in the process you became involved in it,
Town board.
you
Yes.
are expected to keep it confidential until such times.
Yes,
Until the innocent are proven guilty, because that's the way it's supposed to be.
yeah, and as we'll discuss in a few minutes there, Stuart did a significant amount of research, and I reviewed it, and there are.
Thank you, Stuart.
Well, we have a great committee, that's all I can tell
You have absolutely fabulous committee, yeah.
So anyway, the question of how confidential you can keep all of this is somewhat questionable, but I will get to that later.
Okay,
First, I want to answer the rest of your questions.
okay.
So,
Okay, so,
B3, I just have a question about
Sure.
two things. One, I think we as a board are going to have to decide about the subpoena powers, which
yes,
everybody knows where I stand on, but
Yes.
I don't know where everybody else stands on. And the other thing is says within a reasonable time.
yes.
And I always find that verbiage interesting. What, is there any is there a parameter in life of what reasonable is? Meaning, is it the smell test? Do we know that, 6 months to a year is not necessarily reasonable, or it depends upon the size of the complaint, and that's just going to have to guide it, and we're just going to have to deal with it?
Your point is well taken, and obviously the problem that we're grappling with is that the Board of Ethics is a voluntary body, and they obviously, if the members that I've dealt with so far are any indication, they're going to be very diligent. On the one hand. On the other hand, for example, Sandy wanted to come this evening but couldn't because as she was about to leave work, she got called into an emergency at work. So if you have a very rigid timeline for handling things, I guess if you have 5 members of the board, it'll be a little less difficult than what we have now.
Right.
But if you have a really rigid timeline, it could be difficult if you're dealing with volunteers this way.
Is there any way to give a
Say
more or
30.
less, like,
Well, if you-
Because the investigation.
Yeah.
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 Right.
So it-
different people.
if you-
You're always relying on getting a quorum in place, and
Right.
people have schedules. And,
Right.
Right.
It's,
I get it.
If it's a
just-
simple complaint, I'm sorry to interrupt.
No.
If it's a simple complaint that, one person says something and it's just a matter of interviewing 1 or 2 people, you would hope that the Board of Ethics would make a quick decision in less than, say, 15 or 30 days.
Right.
If it's a more complex investigation, 15 or 30 days may not
Right.
be reasonable. So reasonable, yeah, it's a somewhat loose term. It's case by case, but ultimately one would hope that you'll never have to, ask a court to determine in this case what's reasonable.
Right. And if the ethics board got a case that was something that needed to be expedited, you would think that the members of that ethics board, someone else knows about it already then too, so it's usually not something that can wait, and, some actions might already be being taken.
Yeah, I mean, if you want to put a fixed time limit to it,
I
you
don't
can.
know if you can, because I've seen investigations go on for 6 months, because you want to do it right. Not that, I totally get where Kim's coming from, but you want to do it right, too. You want to
No,
do.
absolutely.
you
You're
wanna,
just scared that, somebody needs a response. Maybe it's not the simplest. Maybe it's not 10 people, and then it drags, and they're kind of in limbo. But I understand.
But I think that's.
I get it.
And that's really the reason we're moving the board from 3 to 5 and putting the deputy council or town council as a liaison to the board, because you can get your majority there a lot faster. So,
no
yes, sir.
cookie cutters when it comes to ethics.
No,
Right.
no cookie
They're all
cutters.
different.
Yes, Eric.
So I just have a question. Because I have a suggestion with this clause. However,
Which clause? Which
clause?
clause?
the one we're talking about, within a reasonable time.
Okay.
Here's the problem. I'm tempted to. I've already made some marks here. I don't think anything that I'm thinking needs to be addressed tonight.
Mm-hmm.
I have some suggestions, but I think so I just want to sort of state where I'm at. I've reviewed this about 97 times. Not to this one, but since day one.
Mm-hmm.
And that's an exaggeration, of course.
Mm-hmm.
But this is just from me. I think this is a great piece of work, and although I have some thoughts and ideas on tweaking, like, so here we could write as soon as reasonably practicable versus within a reasonable time. We could tweak a lot, but I think I'm just in favor of sort of sitting back, letting Mark explain what the changes were made, and letting the process move forward, and not try to rewrite it tonight or not try to reanalyze each clause. I'm not saying that this is not appropriate. I'm just saying from this seat, I think I'm just going to sit back and
Well, I think the biggest...
and enjoy the nice work of our committee.
It's excellent, and I think the biggest question that we had on here is the question of subpoena power. So if we get down to the nuts and bolts of it rather than the verbiage, and the verbiage will change, and when it goes, you're going to have people come in on the public hearing and say things like, well, I would like it to say the duties instead of duties, or something like that, and then we meet again and we make those verbiage changes, like you just said, and and stuff like that. But I think the nuts. Excuse me. I think the nuts and the bolts of the thing is to go over some of the big items that people have been talking about, and but we all came to agreement that 5 people is good. We all came to agreement that the council from the town would be the liaison for the thing. We all came to the agreement that it would go to the clerk. Doesn't have to come to the board, doesn't come to the board, and let the process start, so there's no interference. It's almost like anything else that happens, okay? So I think our next big hoop that we're running through is the part about the subpoena power.
Yes.
And I would just like to put my 2 cents in for it. This is an ethics code. You need to have some teeth in an ethics code, and you hope never, we've said this many times, you hope never to have to use it. Should it have to be used, you want to be able to get to the innocence or guilt of the person in an appropriate manner. So if someone makes an accusation against someone, you want to be able to find out in an expeditious manner, so we'll go back to the time frame, as to whether it's true or not. So you want to be able to have the ability to bring people in and ask them the questions, because if someone says, so-and-so says, because, I'll be honest with you, my interpretation of Facebook is like the Inquirer. The Inquirer is for the movie stars, and for the local people, it's Facebook, because, everybody just throws stuff out there. They don't check their facts. They don't do anything. Some people do, some people don't, just like those magazines. So I think you have to have some kind of, my opinion is, it is an ethics code. It's not something we're going to use every day. It's going to be a major thing to have to bring the ethics board together to not ask for an opinion. I think we'll be asking for opinions quite often. Was this okay? Was that okay? I think more of if it gets to a point when you're trying to figure out if someone was unethical, or someone has been accused of being unethical, you need to be able to get to down to the facts, and that's my personal opinion. So you make town sell yours each.
I'm going to ask if we can just go right up above that to the administer oaths.
Where are you?
Can we stay on the subpoena though, and we'll come back to it?
Okay, but I would like to touch on
You
the
talking about
issue
ministerial
of-
to the people that you talk about people that come before them, or administering an oath to? Okay.
Yes.
Yeah.
He's talking-
Okay.
He's saying right before that. So what do you think, I guess,
Well, what do you
I-
think?
I think
Tim?
she's asking.
Who has
Well,
who has the authority to administer oaths,
No, we're talking about
subpoenas?
subpoenas.
Okay.
I mean, that's what the supervisor, Madam Supervisor has asked us if we could. I don't think that we should allow the Board of Ethics to have the ability to subpoena people. I think that generally, if we're talking about the scenarios of complaints, we're talking about generally, somebody, either one employee against another employee, some resident against an employee, or somebody against a company we said that's contracted to do business. There are provisions under employee contracts and all of those things wherein they are, I assume, have to come in and provide testimony or discuss.
I'm sorry, what's that noise? Is that you?
No?
Oh,
Somebody's phone is buzzing.
somebody's phone is on. Yeah, go ahead, I'm sorry, Tim. I didn't
That's okay.
interrupt you. I just heard this
Um,
noise. Just want the phone to-
I absolutely think that anybody who has to come to the Board of Ethics for a complaint is going to answer. There aren't going to be many instances where somebody's just going to clam up. If they clam up, that's a whole nother situation. But I am very uncomfortable with giving the subpoena power to a Board of Ethics, which could then subpoena a outside third party who happened to be a witness to something, which then puts them in a situation where they have to get an attorney, and then to remedy them from having to testify, have to go to a court. I am not for it. I think it opens up a whole can of worms of what a person could get caught up in. And I think that for the most part, people who work for or are employed by probably have to come in front anyway. It's probably part of their provision of employment. I'm sure they sign all kinds of things, and people are going to do the right thing 90% of the time, and you're going to have some people who don't. But I just think that this is not the right way, because I think it opens up very bad things. That's my thought.
Did we have this, sorry.
That's okay. So make sure.
I thought before, we had already said that we weren't gonna give subpoena power to the,
No, we never actually finished the question. So we get caught up in it, and then we put the whole thing away for a while. So now we're going to come up with where we are for this version of it, and if the majority of the board says, no subpoena power, then we'll go with no subpoena power, but if the majority of the board says they have it. I mean, it's not something that I think anyone's gonna use lightly, and it does carry over to Jeff's question of who swears the person in, that's, taking,
but I wanna,
But
I'm
let
not-
him finish
I'm
on the
not
subpoena
finished.
power, yeah.
If the ethics board have the subpoena power, they couldn't come to the board and talk to the board first about what they're about to do?
Not according to this.
Well, it's because, what if it's somebody on the board that they're
The
investigating?
same thing as was just said. It's only the people on the outside or something that they want to, to be investigated. But suppose you want to bring a complaint against the board or somebody on the board. So where do you go from that point?
So if somebody
Stay
wanted,
closer to your mic, Mike.
oh, I'm sorry. If somebody wanted to bring a complaint against a member of the board, they would file the complaint with the clerk's office. The clerk would transmit
Go
it
through the whole
to the Board of Ethics. The Board of Ethics would, in the first instance, review the complaint and decide whether it's got any merit.
Right,
You know,
right.
They might decide just from reading it that there's not enough there to go further and say no, and then transmit their recommendation at that point to the town board, the majority of whom would either say, yes, we agree, or no, we disagree, okay? So that's how the process would work. As far as the subpoena issue is concerned, we were asked to draft a statute which created a more independent board, which is not to say that the present board isn't, but just institutionally by statute makes it a little bit more independent, and to also give the board the power to not only render advisory opinions, but to conduct investigations. Generally, bodies that have the power to conduct investigations also have the power to issue subpoenas, because there are times when you just can't get certain kinds of information unless you issue a subpoena. Now, it's not to say that the subpoena is always going to be used a lot, because in this case, the only way that the board could enforce a subpoena that somebody refuses to comply with is to go to court and get a court order. So it's not like they can just, send out a squad car.
You may very likely write in your report, XYZ, that's a person's name, XYZ, we subpoenaed XYZ, they refused to appear. Now, you're not necessarily going to go to court to have them appear, but you just want to put that as a notation down that they refused to appear. Okay, it's not like when in court where they send a little officer out and they put a warrant. It's not going to be that at all.
No, you would have to go to the Supreme Court.
If it was that big?
Yes. For example, let me just give you an example. Let's say, heaven forbid, a town employee is accused of dipping into one of the town funds, taking money out, and putting it in his or her private bank account. Somebody files a complaint and says, I think this person did that. The board would probably read that, say, we better do an investigation, maybe ask the person against whom the complaint was filed to show them their bank records, and there's a good possibility that that person would say, no, I'm not showing you anything. Okay?
But under that scenario,
The
Board of
ethics
Ethics.
board.
But under that scenario, you're talking about a potential criminal act, and then we would refer it to the legal authorities, and so that would then compel under those. I'm just saying.
Then a grand jury would subpoena the records.
Right. Well, but then that's the bigger.
I
but
think
then that would be the correct body.
Yeah, but I think that Mark was just trying to use it as an
Just
I know,
example.
as
I'm
an
just-
example.
I mean, you can,
And I was thinking also that we have two attorneys on board here, and then you have attorneys. I mean, you could have an argument between the attorneys about who goes where with what at this point. But what I'm trying to say is,
Right.
you have enough legal minds to know where to go with whatever problem comes up. It seems to me like you'd have a team bigger than
yeah, but it's,
O.J. Simpson.
in order, and again, I get what you mean, but in order to get that information for them to make, to them to be able to do an investigation, and really theft might not be the worst thing, the one example to use, but it might be misuse of tools or computer systems or emails or something of that nature. That isn't, you're not going to start that in a court process because that would take forever. So you might want to be able to do that. It's not. I don't think it. I think when you hear subpoena, when people hear subpoena, they hear so and so was subpoenaed, and when they didn't answer this, you hear in the news, and they didn't answer the subpoena.
That's exactly part of the problem is that subpoena carries a hefty connotation behind it from people who are not in the legal field or in the legal field, and so that's a big issue. And if you feel that you're being if you are being investigated or looked at by the Board of Ethics, I think that's enough to make most people uncomfortable. To then give subpoena powers is a whole nother level for people. And I think especially if you're an employee of the town and you just work in a particular department and somebody decides that they're going to make a complaint of some sort, whether it be true or not, the Board of Ethics then has to substantiate or not substantiate it. Whoever is being investigated is not going to be happy about that process. So it's already a concern. You're already worried about your reputation, you're worried about your job, you're worried about many things. And to then give this connotation of subpoena, I think, is a very scary prospect for lay people. You have this look like you don't understand.
That's not true.
No.
He's doing his lawyer face.
Oh, that's
Yes,
the lawyer
yes.
face?
Yeah.
I don't know your lawyer face.
I'm doing my lawyer face. I'm
Yeah, but,
sorry. No, actually,
The whole
though,
a whole ethics complaint is way behind it's a major thing. It's a big difference between an ethics complaint or a department head coming to us and saying, "Gee, I think Sally Sue is, taking paper home. I'm gonna, and we say, okay, we're gonna investigate. An ethics complaint is major unto itself. They should be scared if somebody is doing an ethics complaint. That they should be upset. And I hope we never, ever, ever have to use it.
if
The
I can
opinion
just-
part, yes, but the other part, no.
If I can just jump in for
Yeah.
a second. Kim, you're also assuming that the uncomfortable person who's the subject of the complaint will not want subpoenas to be issued, and that may not be true. Because there may be witnesses out there who will not voluntarily come in to appear before the Board of Ethics, who may have information that would exonerate the person who's accused of the ethics violation. If you don't have subpoena power, then you potentially do not have the power to have that person come in to testify.
I hear you. I mean, we could talk about this forever. I'm not comfortable providing an advisory body, as important as that job is.
It's also an investigatory body.
Okay, but I'm not comfortable for many reasons, some of which I've stated, or many of which I've stated over the past couple of meetings, with providing them with subpoena power.
All you're doing is giving one tool to this board. As
Correct.
it's been stated, it's not necessarily going to be used, and it has to be used very sparingly. The simple reason that if you're going to take the step of issuing a subpoena, and then the subpoenaed party elects to disobey or ignore the subpoena, and then if you don't go to enforce it, then the board looks bad. Because then you're saying that there's information that the board feels it needs, and it's not taking the next step to go to court to enforce the subpoena. So it's got to be used very sparingly, because there are connotations and there are consequences, of issuing a subpoena if it's going to be ignored or if it's going to be obeyed.
But I mean,
Okay.
I agree with that, but you don't know who. I mean, we don't know who 10 years from now or 20 years from now. We don't know who's going to be on the ethics board, and we don't know. People are different. I'm uncomfortable with putting people in a situation where now we have to get lawyers and going to court.
But you might anyway.
You might, but in the
Again,
regular
ethics
course of a.
violation could be very serious if you're an employee of the town.
It could
So
be,
you
but
may
it
wanna
also
get a
doesn't.
lawyer.
It doesn't
It's-
have to be a huge thing. We have seen recently complaints or things that they're serious, but they're not, Supreme Court, higher appeals court serious. I mean, they're
Yeah, but
serious.
that's what an ethics complaint is, because other than that, you're asking for opinion or you're taking care of it in a regular operational thing. So let's get to some other opinions, because this can go on all night. So we've heard a little bit from Northern. We're going to probably hear from Northern again on it. Eric, do you have a comment?
I do. It's more of the same from me. I've given this a lot of thought, and we've talked about this a number of times, and I think I've shared probably at least 2 times previously. And as much as I try to change my mind, because I always try to rethink and think of it from a different perspective, I'm not in favor of issuing at this first draft stage of a law, at this juncture, the right of the board to have subpoena power. I think the right to subpoena individuals takes an investigation to a whole nother level, and I think everybody acknowledges that it does. It potentially could. And I don't have enough of an understanding or an appreciation as to how many times there have been complaints in the past. What is the likelihood that this will ever be needed? Maybe never. I just take something like that so very seriously that I'm sort of maybe for not the right reasons, I'm sort of erring on the side of caution, and that is I believe that this board has an eminently important role for our community, but I think that they should be empowered to do what they need to do at this level and at this time without the need to issue subpoenas. That said, and I think I've also said this before, if we can come up with some language that creates conditions under which I don't, and I'm not suggesting this is this isn't my suggestion, it's just an example. Perhaps where if you have in other words, a unanimous ethics panel requesting from the town board the right to subpoena, that the town board would have the discretion to grant subpoena powers on a case-by-case basis. I think we talked about that. It's not in here. That's fine. But I don't see it right out of the bat, right out of the cage. Just say, okay, sure, take the subpoena power and good luck, and we hope everything works out. I'm not saying that anybody's saying that so loosey-goosey, but to me, I'm just, let's put it in without the subpoena power and see what happens. See how many times the ethics board comes to the town board and says, we really could have done a better job had we had subpoena power.
I will tell you, you hope that the ethics board only meets to tweak the ethics code. You hope they only meet to come up with opinions, and you hope they never meet to come up with a true, because that is up there with appellate and supreme. In my book, an ethics complaint is enormous. I will tell you, and we will definitely go with the majority of the board here. I will tell you that about 6 or 7 years ago, when the village rewrote their code, we gave them subpoena power, and they have never used it. And they've done some ethics inquiries. But that's, and I guess it's right now. It's fine. We'll do it. And you've more or less given your opinion on it too.
Yeah.
Right.
I feel the same way that the other town board
Okay.
members. I'm uncomfortable with this.
Okay, so we can take that out of it right now, and let's get the 5-member board going. Let's get that stuff. This is, again, as in everything in the town board, it's a living document. It can be changed, it can be altered, but I think that, and I hope never, ever to have to use it. 2 years from now, 10 years from now, 15 years from now.
And to your point as well, within the last couple of years, the only time this ethics board has had to meet has been to review the ethics code.
Yeah.
Good.
Yeah. So but I think that we've brought the ethics board we're going to bring it to a new place that we might ask for more opinions than we ever did before, because we want to use the brain trust that we're putting together for the proper use. So moving on, Mark.
Okay.
We're actually turning the page over the ethics.
I can, yeah.
Just touch on that.
He wanted to
Yes.
go with the administering
Administering
oaths.
You wouldn't have to do that if you're not, right? Administrating oaths?
So administering oaths, I believe that attorneys have the power to administer oaths under New York State law.
I think in this situation, it's
Sure,
more
you're
like,
talking into the microphone.
I'm sorry, I think it's more akin to a verification of a pleading, where a person is
Okay.
essentially swearing to the truth of
Oh,
what
right,
they're
right.
stating in the complaint.
To their knowledge is the
To the
truth.
yes.
Yeah. Oh, you're talking about the complaint,
He's referring to the section
The-
which says it's going to.
oh, the written
Yeah.
complaint,
Right,
yes.
the complaint
Yes.
shall consist of a written statement made
Right.
under oath or affirmed.
Yes.
Well, it's almost like any document I sign right now has to be notarized, and I attest to things, and
Yes. So a notary can administer
That's
oaths.
correct.
Is that right?
That's
Yes.
correct.
So, and
I'm
we
a
always,
notary.
and we always have a notary in the clerk's office. We have at least one notary in there at all times, so
Right.
if they submit it to the clerk's office, then they can have them sign a paper that says they're saying that this is the truth. Then it will stop any.
Yeah, I think that's a good thing to have in there.
Okay, so I only had 2 other bolts, and then so my next bolt was the due process thing. So maybe you want to explain. I mean, I'm just concerned that by utilizing the verbiage, and so maybe Eric can weigh in on
Well,
this
due
because
process,
I'm
due process by definition, I hate to get too lawyer-like,
no.
but ultimately, if there's a dispute and if an employee is aggrieved by a finding of the Board of Ethics, that person could conceivably sue the board, and that would happen in a court. So whenever we draft these things, we look in terms of what a court would would think of the language that's in our statute and how the statute was carried out by the board. So anyway, due process by definition means notice and a right to be heard.
Right.
So, you know, what does that mean in every single situation in life? The answer to that question is you spend the first project that I worked on in law school was a question of under what circumstance, if you're entitled to due process under certain circumstances, what process is due? Meaning, what is the nature and extent of the due process you're entitled to? So, for example, in a criminal case, the amount of due process you're entitled to get is higher than the due process you would be entitled to get in a civil case, okay? But what it generally means is notice and a right to be heard. So we're trying to take care of the notice part of it by making sure that the complaints, by beefing up the complaint section of the statute to require somebody who really thinks that somebody did something wrong to state in the complaint what that person did wrong, what the basis of their knowledge is, and affirming or stating under oath that they believe it to be true. That's one way of giving due process to the accused person, so that they're not subject to an ethics complaint filed by somebody who doesn't want to tell you who they are, who isn't taking the complaint serious enough to state it under oath, and who doesn't give specific facts that enable a person to defend him or herself in a hearing. Okay? So that's due process.
You know, I've always thought of due process in layman's terms as basic fairness. You know, it's something that, you know, you look at a process and you say, well, and then again, to use a term that's sometimes thrown around loosely, is it a kangaroo court process? I mean, has a person been given full rights to challenge if something, you know, to challenge and to be heard in a situation? It really is fairness. I mean, you know, it can be it's defined as many things in many different documents, you know, in our government. But that's the underlying principle behind this concept of due process.
I mean, I understand due process. I think it speaks for itself in many ways, but it concerns me that we continue to utilize that verbiage throughout this because I'm concerned that it sets up. I think it just opens us up in certain ways. Instead of simply providing that we will protect each individual's rights through every stage of the proceedings and that those rights shall include, we keep utilizing the due process rights,
It's
the due
interesting
process.
because what you just said oftentimes is what courts call due process when they say what it is, okay? Protecting somebody's rights at every stage of the proceeding. And so I think respectfully that your concerns of having that language in the statute are not realistic. I think what you should be concerned about is that if the Board of Ethics and or the town board gets involved in making findings on an ethics complaint without giving the accused the chance to get a good look at the nature of the charges against him or her, so that the person can prepare a defense, so that that person, if you don't give that person a fair opportunity to call witnesses, if you don't give that person a fair opportunity to testify himself or herself if they want to cross-examine other people's witnesses, then you have a problem. By saying that you want to afford people their due process rights in a statute, in my opinion, you're saying exactly what you should say. But you may disagree.
I agree with Mark 100% on this one. I mean, I think it's an excellent reference.
I agree. But I also point out, I only see it referenced
Well, it's just
once.
within-
So,
Yeah.
No, it
so
says individuals' due process rights at every stage. Due process rights shall include, and then
Yeah,
it says, affording a town employee any due process rights. It says it a lot.
Oh.
Okay, so,
in there.
okay, yeah, well, it's
So I just.
do you have
yeah,
something
it's a good-
else that you wanted to?
it's good.
The only thing I think I had personally was on page 4, number 4 and 5. It talks about who should be provided the findings,
Right.
whether they're substantiated or not, and then who gets a copy of the findings? Because it seems to me that's possibly the subject of the, that was my question. Does the subject get knowledge, and do they get a copy?
Okay, so now we're getting into the question of FOIL, which is Stuart and I and Sandy, and I think the rest of you went through over the last several weeks, or days at least. What we think, it's the recommendation of the board, obviously you can do whatever you want, that until the town board decides whether or not it's going to accept, reject, or modify the recommendations of the Board of Ethics, there's really nothing to show the person who's accused, because there's no final decision made by the town until such time as the town board decides what it's going to do. So for that reason...
Why don't you just clarify that just
Yeah.
a little bit?
Sure.
Because
We're talking about.
somebody accuses
written-
Wayne of
Yes.
something.
Yep.
Only because I looked over and he was here. Yeah, he was
Yeah.
there, right? And yeah, easy target because I looked over. And so you are going to then tell Wayne someone has accused him.
Yes.
Okay. I think that's because
That was it.
yeah.
Oh, is that your question? I'm
You're just not
sorry.
going to provide any written thing because right. So you're going to let him. Sorry, Wayne. You're going to let Wayne know.'re going to let
No,
XYZ know. You're going to let XYZ know that they are the subject, that somebody has alleged a complaint against them, and then the Board of Ethics will do their own investigation or research. And then they will issue an opinion of some sort that would be in writing. That opinion is something that they would not give to the subject until they come to the town board and we accept, reject, or modify, and then that would then be given to the subject. Is that the process?
Yes.
Okay. Thank you.
And at that time, and at that time, Stuart may disagree with me and Sandy may disagree with me, but my
Hasn't jumped up yet. So.
no, but my personal opinion is that once the town board makes a decision whether it's going to accept, reject, or modify, then the person who is the subject of the complaint should be entitled to see the
Yeah.
recommendations of the Board of
Absolutely. Oh, yeah.
Ethics
Is that not in
and the action that the town board decided to take on it, but not until then.
Right. Is that it?
Stuart,
Is that in here?
Stuart needs to come up
Stuart
now.
may disagree.
I just want to
Clarify.
I had sent you all some decisions from the
Yes.
Committee on Open Government.
Yeah.
The important thing to note is,
Can you hear him, Matt?
since
Okay.
it's an advisory opinion from the board,
Right.
only if the town board adopts the exact advisory opinion would the advisory opinion then be discoverable under FOIL.
Okay.
You
Right,
basically
right.
have to take it and make it yours. If you don't, if you change it in any way, that becomes a town board opinion, and it's still advisory from the town ethics board that is not disclosable under FOIL. And we don't think that that's something that should necessarily go out into the public. So that's the difference. If you fully adopted what we came up with, that's different, but you may want to tweak it in some way, and then it still stays advisory.
Okay, so then I have a follow-up to that.
If I may, I'm sorry.
You may.
And I think Stuart's interpretation of the position on the Committee on Open Government, which I think generally takes the position that if there's any agency that's going to take the position that that the work of government should be discoverable
Right.
wherever possible, it's that committee.
Right.
Okay? And that's the position that they take, and Stuart's recitation of that is absolutely correct according to my understanding of it. I tend to be a little more expansive and say, why couldn't a person see the advisory opinion of the Board of Ethics, even if the town board doesn't completely adopt it? Although it doesn't necessarily make a difference, because as Stuart correctly said, it doesn't mean anything unless the town board adopts it, okay?
Right.
But again, that's for you to decide.
Okay.
But what Stuart's saying is accurate.
Right. And if of all groups, that to go there and ask about what is foilable and what is not foilable. But
Well,
Yeah, because, again, you don't want to throw things out there that could be misconstrued or I'm getting that
Right.
dry mouth, or misquoted or anything like that. And I'm going to say this for the 1,000th time. We hope to never have to use it.
But
But-
if XYZ is a subject and they of an allegation or a complaint and they're notified, and then the Board of Ethics does their research and interview in whatever capacity it needs to, does an opinion, gives it to the town board, and the town board tweaks it iota, and therefore it is no longer it's not adopted in its entirety as town board property foilable, but it is still an advisory, right? Am I understanding? I still think a subject should be able to. I agree with Mark. I think
But at that point, you would, the town board members, who are the elected body representing the people in the town of Ossining, could say that. We could, could we?
But
You know.
I think it should be in here to say that a subject should receive it. That upon an opinion provided by the Board of Ethics, being, what's the correct verbiage? Issued, rendered. Very nice. That the subject of that complaint or allegation should receive it. I mean, I would want to know if
My hesitancy, council member, is only this. It's still an advisory opinion. It's not subject, the board hasn't made a final. All the BOE does is give an advisory opinion, do we think, or make a recommendation. A recommendation basically is only the paper it's on. The town board has to ultimately give its approval either way. It's, in other words, that's the final document, and I have no problem providing an employee who's the subject with the final determination of the board. I think basically our deliberative process, which is essentially what the advisory, what that opinion is, should not be disclosable even to that employee, because it's not what is basically the final opinion.
Okay,
We're
so
not
he-
making that final.
But here's the flip side to that. Then if you have a town board who is not interested in what the findings are, because, I don't know, it implicates some of them in some way of bad behavior, and so they therefore don't adopt it, then the person who is the subject doesn't get to see what the Board of Ethics has uncovered and knows. So my concern about waiting for the town board to adopt is, what if the town board doesn't want to for its own reasons?
Well, my only concern is that I think that if you produce the document to the employee before the town board even acts, I think you're creating a whole problem. You have to allow the town board to make a determination based upon a recommendation from the BOE. And then if this town board thinks it's appropriate that it gets released in total, the entire investigative file, that's your determination. I mean, that's ultimate. There's nothing that stops the town board from going beyond FOIL. I mean, if you
And
decide to do that.
that's part of the reason that you have 5 people on the board, so that you have a majority. And so I think that I understand where you're coming from, and I understand that you don't want it to get out before the town board. The town board is the ones that are ultimately responsible for it. And if you have an apathetic town board, shame on the electorate. They shouldn't. And if it's up to a point of, I might be making an ethics complaint a lot bigger than others are, because I think it's a very, 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 very serious thing. And I think that, so I think you want to follow the steps, okay?
I'm just concerned about what happens with the subject.
Well, the subject,
But this provides that the subject gets a copy of the decision in order.
No, but
Can I
Investigation.
just I'm trying to just understand. So no matter what happens, the town board has to make a decision on the complaint. They have to accept it, reject it, or modify
no,
it.
they don't have to.
Yes, they do.
They have to address it in some
Shall
way.
issue
Is
a
that
written
right?
decision in order, accepting in whole or in part, or rejecting in whole or in part.
So
it
where-
says shall
where-
issue.
After that decision
Page
happens,
5,
no matter
number
what the
6.
decision is, if it's approved, rejected, or modified, it will be released. So the town board is bound to make a decision, left, right, or center. Am I?
They have to act on the recommendation of the board.
Right.
They can't
At
simply
which
sit it.
point it will be released, right? So,
Release to the subject.
right. So the town board, apathetic or no, they're bound by this to make some sort of decision.
Which
at
will
which point it
automatically
will be
make them
released.
not apathetic.
Well,
Right, so
Because
the
they are
subject-
bound to do
Subject
that.
gets a copy of the
Yeah.
town board decision, not the advisory opinion.
Right, I think
Unless
that's
it's fully
really,
adopted.
that's really where they're coming from. They're coming from, it doesn't, you don't, the accused or whatever, you shouldn't, probably not a good word to use in
Subject.
lawyer land, doesn't get it from the advisory board, they get the final decision of the town board.
But
Now,
where does it
I
say
can
that?
tell you, I can
Page
tell you
5, number
from,
6,
I can tell you from experience
At the top.
with other
and the bottom.
proceedings like this. For example, sometimes in court proceedings, Eric, you may have experience with this too, and Wayne, a judge will appoint a referee, or the parties can agree to have a referee to actually conduct a trial and make recommendations to a judge. The judge then reviews the recommendations and decides whether or not he or she is going to adopt them in whole, reject them in whole, or modify them somehow. And usually what they will do is to attach to their own decision a copy of whatever they received from the referee, because they have to explain somehow why they're making the decision that they decided to make.
Right.
Right?
Right.
So realistically, there's probably going to, a person who's the subject of a complaint is probably going to see the recommendations and findings of the Board of Ethics to some extent,
Exactly.
because otherwise the town board has no basis for explaining why it did what it did.
But I think I'm okay with the process, the way it's set up. Are you okay with the process?
Yes.
Are you okay with
Fine,
it?
fine.
Sir?
Yes.
Okay. Kim?
Yeah,
Yeah,
if we have to make a reasonable,
Good.
that's fine.
Any other questions on it?
No, I'm good.
Really?
Yeah.
Wait a minute, I slowly turn.
Okay, so
Wait a minute, wait.
No, yeah, Eric,
I'm trying to,
Eric
now I'm
always
trying to
waits to the end.
I'm good.
expedite if there's any other, remember what I talked about
not being
before? Big issue, not verbiage.
You're not getting skipped.
Not verbiage issues, because that
You're
can
being
be
silly.
tweaked during the times of the public hearings, and, somebody might come in and they might say, I don't like the there, or something like that, and they're more than welcome to do that. But I'm looking at the bigger conceptual issues. I think we might, Eric? We,
Wait, Jeff feels like he's,
Uh-oh.
I wanted to skip.
go ahead.
want to be
I have an issue.
Oh,
Okay, go ahead.
Question, and perhaps it can be answered very quickly. Is there a section in the Ethics Code that explains the process during which a complaint is reviewed
with the Board of Ethics.
with the Board of Ethics?
Well,
Is there a procedure that's outlined in this ethics code to state how a decision is going to be made? For example, does it require a transcript of the activity in determining the complaint?
okay, so
That's an example.
no, I understand. So the present code requires that it's 20-9 of the present code, which we haven't changed here, indicates that the Board of Ethics, upon its formation, shall promulgate its own rules and regulations as to its form and procedures, and shall maintain appropriate records of its opinions and proceedings. So under this statute, as it presently exists on the books, the board is required to make its own rules and regulations. I believe that's consistent with Article 18 of the General Municipal
General
Law as well. I think so, yeah.
Thank you.
Okay. Now,
Anything?
Oh, That was my concern.
Anything else? No? Okay.
Okay, now,
Because I think you had a couple other questions, but I think they got answered in our
They did.
conversation.
Yeah, they did.
Yeah.
Yeah, before, oh, sorry. Before our meeting.
okay, I don't want to,
Yeah.
I wanted to add something, but I don't want to cut off anybody's
No,
ability.
no, go
to-
ahead.
Okay, so one thing I noticed as I was looking at the statute that we worked so hard on is that it's interesting because there's really nothing in the present code that talks about this, but
Whose code book is that?
This
Is
is-
it up to date?
I think so, looks like it.
In the ethics code, it would have to be.
The ethics section is up to date. It hasn't been changed.
I don't see any, like, new pages in there, that's
I,
why.
I can tell you that this is, the town attorney was kind enough to let me use this, and it's.
Sir, I have one if you would like it.
But you know what it looks like? I just want to tell you that it looks like this has been very heavily used.
That's what I'm
by-
saying.
by
You
the
can
town
tell the
attorney.
page, the tops
Yes.
of the pages have been,
Yes,
it's not, it is a broken binded book.
I've
you know?
actually transitioned more to the online
Yes,
version.
which is very, very cool, by the way. And we want to tell everyone that you can see the whole code book is online. You type in at the top what you're looking for. Someone asked me about the noise ordinance. I typed in noise. The page popped up. I cut out the link. I pasted it for her to find. So it's very, very easy to use online. Yes.
so something that I want to call to your attention, I'm sorry, I got to get close to the microphone. I think that 20-9 requiring the Board of Ethics to promulgate its own rules and regulations about procedures, I don't think you necessarily have to have it in this code, and it's not here now, but just when you're doing the public hearings, there ought to be a discussion indicating that the Board of Ethics should make its decisions. They should have, I don't know, probably 3 out of 5 to have a quorum, to have the power to
Well,
vote,
since you're
right?
raising the number of people,
Yeah.
which you didn't have before, so you had 3 people and one being the town attorneys in some way.
Right.
So I think yes, you should add that. You should add that in, that it should be a quorum.
The quorum should be 3 out of 5 members,
Right.
not including the attorney advisor.
Right. Exactly.
And also, that any action that they take has to be by a majority of the quorum.
Right.
Or of the board.
Or of the board.
Yeah, of the board. Yeah.
It's not of the,
Yeah.
not
Yeah.
the quorum.
Yeah, because if you do it of the yeah.
That's going to be in the board's, the ethics board's rules, not,
Right, that's what he
not
said.
in
Well,
this.
actually, if the decision has to be, you have to decide whether it's, just like certain zoning matters have to be by majority of the seated, of the appointed board as opposed to the quorum that exists.
Can't be the
I'm just
majority of the
saying,
quorum, I
But
guess.
the rule about how many people constitute a quorum, that goes into their 09 version of their own rules, not ours, right?
Probably in Robert's rules, actually, but.
Yeah.
Probably.
But I'm saying that it doesn't have to be in here, it can be in the ethics board self-perpetuated rules.
I guess, the only thing
Or
is.
does it belong in here?
If you're concerned about due process, you probably don't.
And put it,
want-
please add it to the.
I think it should be a majority of the board.
No, it has to be a majority of the board. It can't be a majority of a quorum. Because then if you had 3 people at the meeting, it could be 2 people.
Right.
That's
It
right.
has to be a majority of the board.
Okay,
yeah.
so the majority of the.
Just like this everything we have to do has to be the majority of the
Fine.
board, not
So-
the quorum.
So we'll add that.
Okay?
Okay.
Thank
I
you.
don't think that's,
And-
Thank you, that's good. That's a good point.
Just the,
You don't what?
just an example of how that works. When the zoning board meets, and the zoning board could have a quorum of 3 members, let's
Yes.
just say, and an applicant comes before the zoning board for a variance application, and that application requires the approval of a majority of the board, not the quorum that exists. The quorum is just authorizes the board to do business, but for it to actually do its business and to render whatever it is, you need a majority vote of the actual seated board.
and that's for every vote taken by this board as well?
He's right. You're right, because if we have a quorum, we can
You can
vote.
You can vote, but you can't vote. You can't be the majority. It's a all of a
I don't know.
language
I don't
No,
know
thing.
the answer.
You can't say, well, we have 3 people here, and a majority of those 3 people is 2 people. You cannot have a vote on that.
you
I would
have
say
to
that
have a
all action of
unanimous-
the board, and it should say it in the law itself,
Right.
should be taken
You
by
know,
majority
you can't
of
say
the
just
board.
because only 3 people showed up at a meeting that
So do all 3 people? Is it
All
written
3
that
people
all
have-
3 people have
Yes.
to?
In that circumstance, all 3 people who are there.
Okay.
would have to be
They'd have to be
affirm or deny. Right.
Right.
Okay.
So, but just
They
as,
can
just,
vote, but they can't, you know.
just for,
So if we're just saying a majority of the board, we don't have to get involved.
Right.
And it's every single, every single board is like that.
no, that's
you know.
not,
No, it is true.
but maybe municipal boards, but I
Yeah.
represent boards.
No, no,
that
I'm just saying, we're talking
Shareholder
about.
meetings.
No,
you
no,
know,
we're
you get
talking about municipal
A
boards.
majority of
now.
the quorum typically does carry a vote,
Okay,
but not municipally.
Right.
I thought
Okay.
a quorum just meant you had enough people to open your meeting.
you
It
do
doesn't-
have
Yes, it
enough
does.
people, but you also, if you were gonna vote on something, you have to have 3 votes, so.
Yeah, I agree.
So that's a
But-
quorum too, yeah. But no, it's not a majority of the quorum, it's a majority of the
Of the
board.
board, okay. It's good.
Good.
The only other thing is that the preamble, which isn't in here, the statement of intent in the statute says, I think it's either 20-1 or, yes, 20-1.
It's actually beautiful in here, I know.
It's what?
It's beautiful in here.
My feet are getting cold.
Okay.
Go ahead.
The last sentence of 20-1 needs to be modified slightly. And I'll just read it. It's
In the actual code book right now.
Yes, it's the purpose of this chapter to implement this objective, I'm not saying what the objective is, through establishment of standards of conduct to provide for punishment of violation of such standards, and it says, and to create a board of ethics to render advisory opinions. Obviously, it should say render advisory opinions, towns, officers, employees.
I thought you just said that's what it said.
For herein, and to conduct investigations.
Oh, I
Needs to
see.
say-
Oh,
has
yeah.
to- Yeah, I was gonna say.
findings of fact and conclusions.
Yeah.
Is that the place where you would put that you need the majority of the board?
No.
Okay, wherever you put that too, you know.
Well, no, 20,
Wherever
We'd
you
have
put
to add a new
that.
sec, we'd have to add a new section.
Okay.
For that. It's not.
okay,
Okay,
all right,
Okay?
we're good.
yeah.
Woo!
Okay.
Now, I have to say
Thank you.
that this particular project, between the work you guys did and the work this board did, was outstanding. You know, it just is, it really, really shows you. Again, we still have to go through the whole process. You'll give the final draft. We'll look at the final draft again. We'll call for a public hearing in, what? Oh, no, what is the change?
We need,
Okay.
there's no change, it's just in terms of process, we have to,
Right.
we have to fashion the actual local law,
Right,
which is
So
gonna.
that's gonna take
Which
time.
is gonna require, no, it's gonna require the final version of everything.
right.
And then we'll do it.
So
we'll do it
let's,
that way.
you know, we have, when we call for a public hearing, if we call for a public hearing next Tuesday, it's 2 weeks after that, so,
Okay,
right?
and I think we have to actually have the actual local law on the website within a week prior to the hearing.
Okay, and that will definitely,
Gives us 2 weeks from today to have
Right.
it drafted and posted.
right. So we'll
you
give you
guys-
1 week from today to have it drafted and posted.
They get.
Well, I can, so.
Well, I
so
mean, my God, we've been working on it forever.
What do you need me to
It was
do right
important.
now?
Well, I'll have to go over with you just to give it, just because the wording in the local law has to be, specific as to what we're removing and what we're adding.
Right,
That's what the local law
Right.
has to state. And how we're gonna renumber it and, adding the sections so that the code people.
and we do
know
want
what
it
to
out
do.
there as long as possible for the public to read it and to be able to ask questions on it.
Right, but the specific steps to be taken, Wayne's gonna have to tell me.
Yep,
Okay,
First things first, when you get this in final version, send
Tomorrow.
it to me.
all right, I can have this by Thursday.
tomorrow. Yeah.
So I'm gonna be out of town most of the day tomorrow.
Okay, Thursday.
Thursday.
Mark, you're gonna miss these meetings where I just keep asking and asking and asking
It's
and
fine.
pushing
I
and.
think it's,
Just thank you for being patient.
Yeah.
it's not,
And like
it's
I
not
s-
a big deal, frankly.
Well,
Yeah, it-
but you see, this is what I was saying with all of the attorneys here. This should not have taken this long.
You know,
That's just my opinion.
We attorneys know how to slow things down to a
Well-
screeching halt.
Well, very much.
You can get all these attorneys. in.
Well, Stuart said it the very, very first night he showed up. He goes, 6 attorneys, 6 different opinions. Yeah, 7 opinions, 7 opinions.
Five.
Thank
Good
you
one.
very, very
Thank
much.
you.
Thank you, guys.
Good night.
Excellent job.
Thank you.
Good night.
Okay, woof.
You know what that
Now,
hangs on your window.
How's the tape?
yeah, it's your little date thing. Okay, the next one is to talk about our planning board interview process. As most are aware, we had a couple of people looking for, that were up for reappointment, and our planning chair has retired. So we have had several meetings We have a process that we're in the middle of, and we have had interviews. We have interviewed 7 people for the planning board for the, we'll call it now 3 places on the planning board chair and 2 slots. We had both people that are on the planning board come to us and ask for reappointment. We will be discussing this in executive session after this, but what we wanted to go over right now is we wanted to go over some of the, and I want to use the right word, because,
Don't use the word.
Yeah, I know.
Changes, just
I put-
changes, don't,
Yeah.
changes.
Yeah.
Just
Yeah.
say changes.
so my quotation marks are always around
Yeah, no,
everything.
'cause-
So how we're going to update the planning board moving forward. The first thing we would like to remind everyone that the next planning board meeting is January 14th. It will be, that is a regular Wednesday planning board meeting. It will be at the library. A lot of times when we need to get the library for the planning board meetings, we actually have to change the day because it depends on the scheduling of the library. But we did get the library. I've been asked that question several times because people know. The agenda is on the webpage for it. It is the farm, and it is some changes, some modification changes to the 558 North State Road project that's out there, development that's out there. We do want to say that we have a formal letter in-house that that is no longer being requested from turning it from home ownership to condominium. So that is over, that we have a letter from the lawyer.
Oh, that's changed?
Yeah. Well, it was, they were going to change it from home ownership to condominium.
They asked
Yeah,
to
yeah,
ha-
yeah,
to-
yeah, yeah, yeah.
submitted a formal
They- Right.
Okay,
which they then withdrew.
okay.
Right. So they have
you.
withdrawn that application, and so, but that, those are the 2 items that will be on the planning board on January 14th. The farm always brings a large crowd, so we want to make accommodations for everybody to be comfortable, so we've gotten the library. What we will do is, after we make a decision on who the planning board people are, we will have a press release on the choices. And then next Tuesday, we will have a resolution appointing them to the planning board. And as I said, the next day is the planning board meeting. And after that, on the 20th of January, and this is what the question you were asking me today, on the 20th of January, which is our next town hall meeting, we will be starting that town hall meeting at, and everyone should note this down, 6:30. And the reason for that is we want the town board to meet with the planning board from the 6:30 to 7:15 timeframe. And one, to show our support for the planning board. We do understand, like these other boards, that we don't go to planning board meetings because it's a reflection of trying to interfere with their job authority. And so we just want to show our support, and we want to go over the process, some of the processes that are changing.
Would you just run by that again?
Okay, so on the 20th, we're going to, the 20th is a town hall meeting, and we're going to start at 6:30 rather than 7:30 at the library. This is at the library too. We'll be notifying the planning board. Some of the things that we're going to be, as we update, good word, update the planning board, we will be establishing a Board of Architectural Review after we investigate with other communities. We'll probably put a committee together to do that, and the purpose is to help the planning board work with developers on the facades of buildings and items like that. It is not to become so intrusive that we become over-restrictive to our residents. That's why we're going to be very cautious when we do this Board of Architectural Review. Yes, sir.
What was, I'm sorry,
That's okay.
the farm, what were you saying about, did I hear you say a farm?
Well, there's a farm that's in front of the planning board that has a between 24 and 28 housing development trying to go on to it, and it's kind of a controversial. What would you say, Wayne?
It's an application, it's a subdivision and development application.
Where is this?
It's out on Barnes. Okay. Okay.
It's not not to create a farm.
No,
It's
it's
this,
the opposite.
it's just the,
It's the
it's the
opposite.
reference to the property.
It was a farm.
It was a farm.
At one
and
point, it's history.
It had, how many acres?
Oh, yeah, yeah, yeah.
I-
32?
You don't remember the exact age.
No.
30?
It's 36 acres.
36 acres.
It's burned into my brain, all of these figures and everything. So anyway, we're going to be, as I said before, we're going to be establishing a Board of Architectural Review. We are going to begin having the planning board session filmed and broadcast on public access government television. During this, it's not going to happen instantaneously. It won't be for the 14th meeting because of the fact that we have to schedule people and make sure we have cameras available and what have you for that. We will begin posting minutes for all planning board meetings as soon as they are approved by the planning board. In the past, we have waited for the town board to accept them, but as soon as the planning board approves them, we will then be posting them on the webpage. Sometimes what happens, and people get a little confused over this, if a few months go by and there's no planning board meeting, then the minutes from the previous meeting have not been accepted. So I think that during this year, you'll see at least a planning board meeting a month with the type of projects that or developments, I should call them, I hate the word project, that we have going on out there. We were going to review notification to residents, commercial property owners, and surrounding municipalities as far as giving them notification as far as if a development is going in near you, how many feet away, 200 feet, 500 feet, whatever it is, we're going to be investigating what other municipalities are doing and making sure that we're right in tune with that, and making sure that we notify other municipalities when we're close to the borders, i.e., this farm, because we're right on the part of the property is in Newcastle. Yeah. So those are some of the things that we're working on. We're very excited about moving forward on this update of the planning board. And as I said before, we will be discussing the different interviews that we went through at an executive session tonight and coming up with a results after that. Yes, ma'am.
I just wanted to chime in on one more thing. I'm not sure if you were getting to it. Another change that the board had decided would be appropriate is putting the plans in PDF and posting them
my
to
gosh,
the
one of the
website.
biggest things going, right. We had been, other communities are doing this, and we are now asking every developer of every stage of their application that they produce any drawings that they have and everything in PDF form. And the reason we went with PDF form, it's the easiest for the average person to open up on their computer. If they get too sophisticated with these other programs, then you can't open them up. So we have started that process. I think we have our first set. I think the farm and 558 went up. 558 North State Road went up on going up to the web page. We will put in our next supervisor's update, which will be out very, very shortly, how exactly you find that, but you go into the left column. What's the easiest way?
The easiest way to find it right now, I'm working with our webmaster to come up with something a little bit more user-friendly, but basically what you can do whenever you're looking for a document on the town website, go to townofossining.com, and along the top row, you'll see something that says publications. If you click on that, you'll see all the lists of all the different places that something could be, and that's the easiest way to access every single document that we have posted, rather than going to the left side. They're all in folders, so the first folder would be A, assessors, B, budget,
Okay.
C. So you obviously go all the way down to planning board, and then I've named them all HVF for Highview Farm, and then Briar Commons.
Yeah.
So there's no search?
Our website doesn't allow you to search, but I mean, at this time, there aren't so many documents that it should really become an issue. We're looking to batch them in the planning board section anyway. Well, in the town board section, if you're looking for, say, a 2013 voucher, there's a folder that says 2013 voucher, and then you can go into that folder and go by date. But there is no search function on the website that we have.
2015. It's 2015.
It's also.
Search on the website. That's all.
You can search when you want to look up the code and stuff like that, but I think that all in all, our website is extremely user-friendly and
It's much better than it used to be.
and it's
for
much
sure.
better than it used to be, number one. Number two, and it's much better than 90% of the other ones that I've tried to go on just to look up something in a municipality. I'm not talking about, I'm not talking, so right now you go to the department that you're looking for, and I think it's very user-friendly. And when we have stuff that we know, we throw a little blurb out on the side or something. Or
Everything
we
goes
put
up
in
to
the box
front
in the
news
top.
page when it's current, so that's the easiest way to
Right.
find something that this board or the planning board is talking about
But it's,
currently.
but it's also important to know that every single version of, let's say that my building, I'll call it my building, and I'm on the third version of the application, third version of the prints and stuff. All three versions will be kept on the webpage, so that you can go back. You can say, "Wow, I don't remember that patio being on there," and you can go back and look it up and see what it was in the beginning and stuff. So it's bringing everything up, it's to the next level. But I do believe that it is a very accessible webpage too. So, okay. So that's really it, but that's a lot of things that are going to change in the planning board update. So we want to thank you, and I think this was an extremely important meeting, even though it looked like a short meeting if you looked at the agenda, but it's never short when you're talking about very, very important topics. And we would rather keep it a few very, very important topics, and then we can move on to the next. I already told someone, I said, well, when this subject gets done, we will move on to this subject, the next one. And that's the way a board should run. So I want to thank you all. Thank you for coming. We're going to move into executive session for personnel. Do I have a motion?
Motion to adjourn into executive session for personnel.
Second. Did you learn a lot? Did you learn a lot? I did. All those in favor?
Aye.
Aye.
Bye, Gareth.